Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources. I'm Kerry Fink, and welcome to Helping Seniors Television for today. On behalf of Joe Steckler, our president and founder, and the entire Helping Seniors team, we sure do hope that the information you get from today's program is going to add to you and your knowledge and how you develop your own aging plan. And today's topic is really an interesting one. It is one of those, terms that for those of us who are not in the legal profession, it has that air of legalese. And I am so glad that today we have as our guest, longtime friend of Helping Seniors, board-certified elder law attorney Bill Johnson, to help us work our way through this, because Bill has a great gift at being able to take what seems like these complicated phrases and legal concepts and bringing them down into a way that we can understand and see how they're applicable to our life. And so welcome, Bill.
Thank you, Kerry.
And the words for today are durable power of attorney. Now that's a string full of words right there. What does it mean?
Okay, that's a great question to start off. Durable means that if you become incapacitated, the document still carries on.
Okay.
So the document survives the mental or physical incapacity of the person who made it. Power of attorney is where you give somebody the power to act on your behalf, and they become your agent. Sometimes they're called your attorney in fact, and they can do whatever powers you have given them.
So if I'm like an adult child of an aging mother or father, and they are going to a hospital and the doctor turns and says, well, you're the son, this is what we need to do with mom, she can't answer right now. Is that sort of in that same?
Well, we have another document in Florida that deals with healthcare called a healthcare surrogate.
Okay.
Where somebody would make your healthcare decisions on your behalf. However, there's nothing from preventing you putting those kind of provisions in a durable power of attorney as well. So some states favor a durable power of attorney for healthcare. In Florida, we have a different kind of document called a healthcare surrogate. They take over immediately, or when a doctor denotes in your medical file that you're unable to give informed consent. So, and you designate on the form which of those applies. Is it immediate or, when you're unable to give informed consent?
So this brings up another question that as we're exploring, so we get this right, durable power of attorney then might also have to do with things like bank accounts and things like that.
Generally in Florida, it's going to deal with financial accounts. So in the power of attorney, we want to give somebody the power to deal with everything financially that you may have. Generally, this is going to be about 12 pages of boilerplate because it's going to take into account every sort of financial circumstance that may occur. In Florida, you specifically have to give somebody a power or they do not have it.
Okay.
So you can't just say, I give Kerry the powers to act on my behalf on anything financial. That is not specific. That is a broad grant of authority, won't fly anywhere.
And how does that work? Because a lot of times we hear, of a mom or a dad saying, well, I'm just going to put my son or daughter on the account. That way they can just, whatever they need to if I can't. Why is that a good idea, or maybe it's not a good idea?
Well, one of the problems is you make them a joint owner typically, okay. And when you make them a joint owner, it becomes subject to your kids' creditors, whether it be the IRS, the guy they ran into by running the stop sign, or the guy who's suing them over some bad business transaction. So you don't want to make them a joint owner on your assets, even though that's a quick fix. The other thing is, that doesn't solve all your problems. You still need somebody who can sign your tax returns, deal with regulatory agencies such as the IRS, or maybe a state Medicaid program trying to qualify them for Medicaid. So they need other powers too, not just access to your bank account.
And so I guess maybe a question that's kind of related to that, I think you may have answered the question implicitly already, but I guess a difference between putting a kid on the bank account versus having them be your power of attorney because you trust them and think they would do the right thing would be that then your assets are shielded from anything that would happen to them externally.
Correct. Your assets aren't subject to their liabilities. And vice versa, too. Your liabilities don't attach to them just by virtue of them being your agent.
So in other words, if they're helping you and then something comes out of the woodwork, they're not having, they can sort of be at arm's length with that.
Correct. You know, say I owed somebody $50,000 and they were coming after me for that. Just because you're acting as my power of attorney does not mean you're personally responsible to pay that $50,000. You would pay it out of my monies if I had the $50,000, but you did not have to pay it out of your own personal monies.
And that's an important distinction, isn't it? I was going to say, viewer, I was going to remind you that there are a number of excellent television shows on the Helping Seniors website, helpingseniors.brevard.org. You can also find them on our YouTube channel, which is Helping Seniors of Brevard. And actually, they're also out on our Facebook page. We have the videos posted there as well. But you and Joe Steckler, our president and founder, have done a number of TV programs over the years where you've tackled a lot of these questions. And one of the things that I keep learning as I watch those is that it makes a great deal of sense to, number one, get your documents done properly so that they serve, because at the time you're going to need them, you're probably not going to be able to do much about them. So you need to have this set up ahead of time. It does seem like a durable power of attorney would fit into that category, because at the moment that you really need somebody to be able to help, they need to have the authority to act.
That is correct. And so if you're trying to pinch pennies and you go by a form, one is you have to be assured that form is up to date. Right. And I get forms in my office every day that haven't been updated in 20 years. And people come in with these forms that somebody gave them that, for example, just say that person can do whatever I, could do myself. And I have the regrettable position of having to inform them that the piece of paper they have is worthless. Right. And so subsequently, the advantage of going to a lawyer's office is hopefully you're getting the latest, greatest version of something that is up to date and in compliance with the new statutes. And speaking of new statutes, we just had one in 2011 that dealt with durable powers of attorney. It gave us some magic language we can put in the document. We can, instead of trying to explain everything you would do at a stockbroker's office, we can just use the words, my agent can do security transactions, and that covers all of that. And then they gave us some magic language for banking. So my power of attorney can do banking transactions, so we don't have to spell out deposit, withdrawal, write checks, all that stuff. For everything else, though, we typically have to spell it all out. Also, what we call the superpowers. These are very broad, and sometimes controversial, I guess for lack of a better word, powers that you may give somebody. Those have to be actually initialed next to or signed in the body of the document. So any power of attorney after 2011, you have to sign or initial next to these superpowers if you want to give them to somebody. They are like changing beneficiaries on life insurance. Oh. Things like that, or creating a trust. So you specifically, even more so, have to give them that power and sign off on it. I can't tell you how many powers of attorney I get in, even now, where they give that authority and there's no signature or initial line.
Yeah, I do remember very specifically, folks, that there is a TV show that you and Joe Steckler did specifically about this concept of superpowers. And I remember one of the takeaways that I got from watching that episode was the fact that a lot of times we may have had things done. We moved in from out of states. We joke, a lot of times people aren't really from Florida. It's rare that you meet a native Floridian. Most of us arrived here because we were in some other state and we moved to Florida, maybe to retire or whatever. But it does seem like we've had this conversation many times that, something has been done or put together in another state, but that doesn't necessarily mean that it's appropriate. So if somebody had their durable power of attorney set up, years ago in, I don't know, let's pick on Illinois, and then they've now chosen to retire to Florida, is that valid? How do we know? I mean, I know that's one of the reasons somebody should visit with you about it, but how do we know?
Illinois was a great example, by the way. In Illinois, they have a statutory form for powers of attorney that is what we call a check the box. So you say, I give my agent the following authority, and it says real estate transaction, banking, securities, whatever, life insurance. And even though Florida has a statute that says that if you have a valid power of attorney executed validly in another state and you bring it to Florida to be valid here, that typically is not the problem. The problem is our statute also says we will specifically interpret powers of attorney. And that's where these run afoul. So a check the box, which Illinois has, and so does New York, don't work in Florida.
Wow.
Because the term real estate transactions is too vague. So in Florida, we would have to say the power to transfer, mortgage, sell, real property, including my homestead, and all this other language. Just simply real estate transactions is way too amorphous and vague, so that in Florida, we would, if you moved here from Illinois, yeah, you think you're covered, but in Florida, we would really want you to redo that document to a Florida durable power of attorney. So Illinois was a great example.
Wow, and I think you've probably already answered the question about why it may not be a good idea to grab an online form or something you picked up at the office supply store for the same reason. Apparently it does matter, state to state, I guess.
It really does. A lot of these forms are one size fits all with all the states. I can tell you when the law changed in 2011, a lot of people who were selling the online forms never updated their documents for a year. So they had all these people still executing these documents that were actually out of date. And additionally, if you're going to a store and buying them, I can tell you a lot of the office supply stores that sell these documents some of them haven't updated their forms since the 90s.
Wow.
So I still get people coming in with forms, and you can clearly see in very small print in the top right that this form was last revised in 1999. So way out of date, not going to do what you think it's going to do, and you're not covered. And the problem is, when you think you're covered and somebody has a stroke or Alzheimer's, and then you don't find out you have a bad form until you go to the bank and try to use it. And all of a sudden it's rejected. And now you're stuck having to go to guardianship court to become guardian of the person so you can get access to these accounts. And that is a whole nother process, a very time-consuming, invasive, and expensive process.
I have heard this horror story a lot. We operate the county senior information helpline. I'm going to give that number now. That is a free call. People call us. That's what we do as a 501c3 charity. We help people via the senior information helpline at 321-473-7770, 321-473-7770. And we get calls all the time, but one of the calls, and usually, as you might expect, there's a crisis going on. Somebody is now in the hospital. Somebody connected is having to make an emergency mortgage payment, a rent payment, or something like that. They wander into the bank with not the right forms because they're trying to get Aunt Susie to pay from Aunt Susie's account, and there's a problem. And this is what you're getting at about what the durable power of attorney could help with if it was properly done.
I've had to do several guardianships just because the power of attorney, as you know, I help people qualify for Medicaid benefits.
Right.
Well, the patient can only have $2,000 in assets.
Right.
So a lot of times we have to divest the patient of their assets. And one of the things that counts towards that $2,000 limit is cash value in life insurance. It's the face value of all your policies combined is over $2,500. So typically people don't think of cash value in life insurance as an asset, but it is. It's basically a bank account. And subsequently, we get all these powers of attorneys that do not address accessing cash value in life insurance. And even though they address everything else you may need, because of this one life insurance policy with $5,000 of cash value, this person can't get Medicaid and now is going to have to pay the nursing home $10,000 each month. And we have to, file an emergency temporary guardianship, get in there, get the authority to get this cash value out so we can get them on Medicaid. But, every month that goes by, that's a $10,000 hit. And subsequently, if the power of attorney had been drafted a little better, we wouldn't have had to go through that drill.
This is the drumbeat that happens. And folks, if you take the time and educate yourself and watch through these different programs, getting this information early when it makes sense, it doesn't save you hundreds of dollars. It doesn't save you thousands of dollars. It can save you tens of thousands of dollars is what I keep understanding, because the very thing that you just mentioned about guardianship, which most of us don't really even understand clearly, but when somebody becomes incapacitated, now they're in the hospital, they can't make a decision for themselves, and everybody's scrambling around trying to find paperwork. If the paperwork can't be found, then our only option is a guardianship.
Correct, and that's where we have to go to court, have the person legally declared incapacitated, and then have a guardian appointed, if they're found to be incapacitated, to exercise their rights. Of course, if you have a situation like a second marriage, you may have the new spouse and the kids from the prior marriage all wanting to be that person, and then you have a conflicted guardianship because you haven't spelled out who you want to make those decisions. So now everybody throws their hat in the ring, and then we have basically a guardianship trial to see who's the proper person to make those decisions on your behalf.
And we all know that all that's for free, right?
Yeah.
That could get really expensive really quick.
I've been involved in some of these that have gone into the hundreds of thousands of dollars in legal fees.
And all of this could be prevented by sitting down and creating the durable power of attorney.
And spelling out who you want as your decision maker ahead of time.
And I know that I've heard Joe ask you this question. We're not talking like this is an expensive process. This is fairly reasonable to get that level of peace of mind and knowing that what you want to have done, if you can't make those decisions, is going to get done the way you would prefer for them to get done.
And there's some common misconceptions out there. One is that just because you're married to somebody doesn't mean you can sign their name. You do not have that authority. And subsequently, if you go about signing your spouse's name, you've committed a crime, which we call forgery. A lot of people who are married think, oh, we own everything jointly. Why do we have to have this document? Well, typically you don't own everything jointly. A good example would be an IRA or a 401k. You can't own that asset jointly. It's only in one person's name. And subsequently, if your spouse gets ill and you're trying to get into their 401k to pay for their care needs, guess what? If you don't have the power of attorney, you're going to have to do a guardianship. Also, what happens if you want to sell a joint asset? So you have a spouse who has a stroke, they're incapacitated, and you want to downsize your house. You want to sell your house. Well, your spouse can't sign. Who's going to sign on the deed? Well, if they haven't given you a power of attorney, we're back to doing a guardianship again. And guardianships, just even bare bones uncontested ones, typically run in $10,000 range. So
it gets expensive real quick when you start talking about that. And one of the things that we were talking about before we rolled the cameras, this is an observation. I said to Bill, I said, I hear the term estate planning, and it immediately summons up this the opening of Beverly Hillbillies, where they're talking about swimming pools, movie stars, and all of that. But the term, so I think a lot of people look at this term of estate planning and say, oh, I'm just small potatoes. I don't need to really worry about all that. I don't have all that stuff to think about. But the point is, as we're talking about topics like durable power of attorney, or we recently did a TV program that I invite you to check out about probate, learning about how to literally avoid probate and save potentially tens of thousands of dollars in that. These numbers add up real quick, even for, like, I would say, regular folks.
They do, and a little simple planning could go a long way. I just wanted to mention one other thing. One of the misconceptions is just because you have a document that says durable power of attorney doesn't mean it's going to let you do everything you think you can think of. Remember at the beginning of the show, I talked about your agent only has the powers that you give them. So if you have not read your document, you may want to go back and read it, because those are the powers that they have.
Yes.
Not anymore. A great example, again, I'll go to the Medicaid world, is sometimes if the patient's income is over a certain limit, we have to do an income cap trust, sometimes called a Miller Trust, sometimes called a qualified income trust. And we use this vehicle to artificially reduce somebody's income to make them eligible for Medicaid. Well, there are only a few people who can sign this, one of which is your spouse. Mm-hmm. If you don't have a spouse, then if you've given somebody that authority and a power of attorney, wow, they can sign it. And I can tell you a lot of powers of attorney that I see haven't delegated that authority to create a trust. And the third is a guardianship. So if you're a single person, you need Medicaid, and you have a high income, it's very likely that you may need a qualified income trust, especially if you don't have long-term care insurance. And if you have not given somebody the power to create that, we may be right back into doing a guardianship. So just because you have a document called the durable power of attorney, don't rest on your laurels there. Make sure you know what's in the document and what powers you've delegated.
Yeah, and the other thing that's so important about what you're saying is there's two functions here. Number one, you might be able to find a document. That might be fine. It might have all the language in there, but probably, as you were talking about, I was thinking, particularly as you were talking about this particular example, I was thinking most of us wouldn't have a clue why that would even be applicable. So we would just skip right over that and not even think about it. But that really, to me, shows the value of sitting down with an expert elder law attorney who can interpret and say, we do need to talk about this. This is when this might actually apply to you. What do you want to do about this? And I assume that's part of the process that you go through when you sit down and you help somebody draft up a correct version of a durable power of attorney.
Correct. And, in ours, we have all these clauses, but we do review people's documents for free to make sure it does what they think it does, because a lot of times, as you mentioned, they would have no clue as to what needs to be in the document.
Wouldn't that really be also, I guess, a real reason to sit down and just kind of have a consultation, to just bring in the paperwork, say, well, this is what I have, this rental property over here. I have, maybe I'm a snowbird. I have, property up in this state here, and then we have our condo down here in Florida. And so it really seems like bringing the specifics to an expert who knows how to interpret those to your best advantage makes sense. And as I follow, number one, you're willing to sit down and have that initial conversation at no cost, and then give them a recommendation or a plan, what's appropriate to go forward. And so as we're talking about this, it seems like pretty easy when you take these scales. If I misstep, this could be $10,000, $20,000, $30,000 the wrong direction. But if I sit down here, it's going to be free. And even when we get to putting some documents together, it would be nothing relative to the other side of that scale.
Right. And as an elder law attorney, I typically look at three different areas. One is the estate planning side of things. The second is the incapacity planning. How, do you have your decision makers in place? Do you have your end of life wishes out there? And then the third is the long-term care planning. And sometimes knowing how all three of these areas mesh together is very useful in doing somebody's plan.
See, that's the whole value of the expertise. My wife and I were laughing. We were watching an old episode. You remember the show Candid Camera?
Yeah.
And they had a gag where they had a person sit down in a dentist chair, and the dentist walks in and says, "Oh, you're the first patient I've ever pulled a tooth from. I'm so excited I get to work on you first." And you could just see the color drain out of the patient's face before they revealed it was a gag. But I was thinking, that is the value of expertise. You don't want somebody who's never pulled a tooth before pulling on your tooth. And when you're sitting down and talking about significant impacts to your financial life, you really don't want somebody who's never pulled a tooth before. You want to go to somebody who knows what's going on. Bill, how do people get in touch with your office if they want to chase this farther and maybe set up a time to either have documents reviewed or just sit down and talk with you and get some ideas of where they should be on all this?
Well, they can reach us, call the office at 321-253-1667. We're located out in the Suntree area of Brevard County, just north of Melbourne. Or you can go to our website, which is floridaelderlaw.net, all spelled out.
Really good advice. So as you're thinking about that durable power of attorney, right now is a great time to pick up that phone, give Bill's office a call, set up a time, let him at least go through what you've got to start with, or better yet, have a chance to sit down and make a good plan. As Joe Steckler, our president and founder, likes to talk about, that's something we all need to work on, getting a good aging plan together. So thank you, Bill, for joining us today.
Oh, you're welcome.
And thank you, viewer, for joining us for today's episode of Helping Seniors Television.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.